Can you be imprisoned for non-payment of debt? Can you be imprisoned for non-payment of debt? Have you been screening your phone calls to avoid collectors who are constantly nagging you to settle your unpaid credit card balance? Have you been threatened to face a lawsuit if you fail to repay a lender? If incessant calls from creditors cause you to be allergic to phone calls, being armed with the basic principles of the consequences for non-payment of debt can give you greater peace of mind. In fact, it can be a whiff of fresh air if you heard the statement that no one will end up in jail for non-payment of debt. Before you allow paranoia to feast on you, know more about the laws associated with unsettled debt. Some common laws that are said to violate the constitutional prohibition against non-imprisonment of debt. Credit cards. The Access Devices Regulation Act of 1998, RA 8484, states that any person who obtains the money or anything that is valuable with the use of an access device with the sole intent to defraud or with intent to gain and fleeing one's motive has been executed will be held liable for a crime punishable with a fine and imprisonment. In addition, a cardholder who intentionally abandons the residence, place of employment, or business that was declared on the application or credit card without informing the credit card company of the current place where he could be reached will also be liable for a crime. If during the abandonment the person has outstanding and unpaid balance which is past due for at least 90 days and is more than 10,000 pesos, the individual shall be prima facie presumed to have used his access device or credit card with intent to defraud. Bouncing checks. Bouncing checks law, BP 22, has also been viewed as a violation of constitutional prohibition against non-imprisonment for debt. In the context of this law, the non-payment of an obligation is not its main concern. The law is not designed to force a debtor to settle his debt. The main purpose of the law is to prevent anyone with the gumption to make checks that don't have any value with the intention of putting them in circulation. Checks have become a substitute for cash and widely accepted as a medium of payment, especially in trade and commerce, and when the confidence of using this checks are marred due to its misuse, its value and usefulness will also be diminished. Trust receipts. Trust receipts and bouncing checks share the same argument based on the Trust Receipt Law PD 115, which states if a person fails to turn over the proceeds of the sale of goods which are considered covered by a trust receipt, or if the person fails to return said goods if they have not been sold, penal sanction shall be imposed. The punishment is due to the abuse of confidence and dishonesty in the handling of goods or money. Non-imprisonment for credit card debts. The question that is frequently asked as far as a credit cards are concerned is whether one may be imprisoned for failure to pay credit card debts. This has often been posed by no less than the credit card holders who, for some reasons, failed to pay their credit card debts. In order to obtain the desired answer, there is an imperative need to examine the applicable law on credit cards, and for similar purpose, it is equally important to take a closer look at the pertinent provisions in our Constitution, particularly those found under the Bill of Rights. Here in the Philippines, the law governing credit cards is Republic Act number 8484, RA 8484, otherwise known as the Access Devices Regulation Act of 1998, approved by the 10th Congress of the Philippines. On February 11, 1998, RA 8484 is an act crafted to, among others, regulate the issuance and use of access devices and prohibit fraudulent acts committed in relation to such devices. An access device is defined under RA 8484 as any card plate, code, account number, electronic serial number, personal identification number, or other telecommunications service, equipment, or instrumental identifier, or other means of account access that can be used to obtain money, goods, services, or any other thing of value, or to initiate a transfer of funds other than a transfer originated solely by paper instrument. While a credit card, which is included within the meaning of an access device, is defined under RA 8484 as any card plate, coupon, book, or other credit device existing for the purpose of obtaining money, goods, property, labor, or services, or anything of value on credit. Upon careful reading of RA 8484 in its entirety, it becomes apparent that mere failure to pay credit card debts is not among the prohibited acts constituting access device fraud, which are declared to be unlawful and thus punishable with a fine and imprisonment. What is punishable under RA 8484 is the act of obtaining money or anything of value through the use of an access device with intent to defraud or with intent to gain and fleeing thereafter. Notably, as far as the element of intent to defraud is concerned, RA 8484 provides for a prima facie presumption to the effect that a card holder who abandons or surreptitiously leaves the place of employment, business, or residence stated in his application or credit card without informing the credit card company of the place where he could actually be found. If at the time of such abandonment or surreptitious leaving the outstanding and unpaid balance is past due for at least 90 days and is more than 10,000 pesos, shall be prima facie presumed to have used his credit card with intent to defraud. Nevertheless, what is clear from RA 8484 is that mere failure to pay credit card debts in the absence of fraud will never give rise to any criminal liability on the part of any credit card holder. Even assuming, just for the sake of discussion, that mere failure to pay credit card debts is among the prohibited acts constituting access device fraud, which is discussed, are declared to be unlawful and thus punishable with a fine and imprisonment. Still, it will be struck down as void and as such of no effect for being unconstitutional, it being in direct contravention of the constitutional prohibition against imprisonment for debts. Under Section 20 of Article 3, Bill of Rights of the 1987 Constitution, it is explicitly provided that no person shall be imprisoned for debts, and this no doubt includes within its scope credit card debts.